Committee members, we are back in session for the second part, which is consideration of the private members bill. Bienvenue, Madame Vien.
Welcome, Ms. Bien.
To the order of reference of Wednesday, September 25th, 2024. The committee is commencing its study of Bill C-378, an act amending the Canada Labour Code, complaints by former employers. And we have one witness appearing with us today, Madame Dominique Vien, MP, who is the sponsor of the bill. Madame Vien, la parole est à vous.
Ms. Vien, you have the floor for 5 minutes. Thank you very much. Hello, everybody. Thank you for welcoming me this morning. I'm a little bit emotional here because the last time I appeared was when Bill 176 was tabled in Quebec, and that was for the review on the labor standards. That was part of this huge review, and there was a major change that was brought for workers in Quebec, namely to take everything into consideration and take the time required to lodge a complaint when you're dealing with harassment or violence. At the time, I saw that Quebecers only had 3 months to file a complaint. And so we wanted to take steps to bring that up to 2 years. And I would like to show you that in Quebec, that was an excellent decision. That was very fruitful for a number of Quebec workers. So obviously, when coming here to Ottawa in 2021, I was chosen basically out of a hat among all of the members and asked what I could table as a bill here. So I rummaged through the Canada Labour Code, and I saw that the CLC had some discrepancies versus what was going on in Quebec, but also with regard to what was going on in other provinces. In Quebec in 2018, the deadline was brought from 3 months to 2 years. In Quebec, there is no difference between current employees and former employees, which is not the case here at the federal level. For all of the organizations and organizations that fall under the federal government purview, and up to 2021, there was no deadline to file a complaint by former employees, but with Bill 65 from the current government, that problem was resolved. If there isn't any deadline, there isn't any time limitations under the Canadian Charter, but it was still a challenge for former employees because they didn't have any recourse. But now, with Bill 65, there's this 3-month period. You can say that 3 months is better than nothing, and that's true. It's not far from nothing. But what we are proposing here with today's bill is it's a small bill, but I think it could nonetheless have a huge impact. The impact would be that former employees would have at least what is granted in the province that is the most permissive, let's say, namely Quebec, which is to have a 2-year deadline instead of 3 months. On the government side, there was some concern, and there was also the concern that the parliamentarians had, that 3 months was a short period of time. And why is that? Because, well, Parliament thought so as well. Because within the application rules, it is explicitly said that there could be permissions asked for an employee to have a longer deadline. So it was recognized that 3 months was a little bit short. So with regard to what's going on outside of Quebec, well, there are 5 provinces that don't make any distinction between former employees and current employees. but they just give 1 year, a 1-year deadline in Prince Edward Island, PEI, and Ontario, and Newfoundland. Newfoundland gives 6 months. BC gives a 6-month deadline. And there are other provinces, 3 provinces, Alberta, Manitoba, and Nova Scotia. They offer no recourses to former employees at this time. Not giving any time for former employees to file a complaint makes no sense. Giving 3 months to former employees is also showing a lack of empathy, because we all know that it can be very complicated for former employees or current employees to recognize what was really going on, what happened to them. Obviously, that is a period of mourning in a way. It goes by very quickly. For all of these reasons, I think that we should do some good work here and move forward to make sure that former employees have more time to file a complaint. That's what I had to say. Thank you, Ms. Vienne.
With Ms. Gray.
Thank you, Mr. Chair, and thank you for being here, Ms. Vienne, and for putting forth your very impactful private members bill. Ms. Vienne, we know that this year Statistics Canada reported that in Canada, 31% of men and 47% of women reported experiencing some form of harassment or sexual assault in the workplace. Worse yet, a survey last month by Tralient reported 61% of Canadian HR professionals say harassment is a growing issue. This Liberal government in so many ways doesn't focus on victims, and I'm wondering if you can speak to that and how your bill will impact people.
Well, look, psychological and sexual harassment, violence in the workplace, it's nothing new. It's been around for a long time. We have to put an end to it. And I think the way to do so is for people to be able to talk about what happened in their workplace. You are entirely correct. The statistics are alarming. I was able to get some others from the CLST, which is the organization that looks at workplace standards. We have to look at helping employees and giving them some compensation. They really look at protecting employees. And Statistics Canada has also noted what's going on. With regard to the reports that are sent by government organizations or other organizations, they have to provide reports to the government. And yes, there has been a notable increase in harassment and violence in the workplace. I have to weigh my words here, but it seems to me that in your personal lives, in your civilian lives, regardless of what you're doing in public life, you can see all of this in social media. The work is not completely separate from what is going on elsewhere. We think that with this bill, there will be some tools given so that when there is harassment or violence in the workplace, this will not be tolerated. We want zero tolerance. Let's give some time to former employees to actually exercise their rights. Right now, they hardly have any time to do so.
Question: could your bill have an impact on current employees, or is it strictly reserved for former employees?
C'est une excellente question parce que
Excellent question. Because there are a lot of examples that can be cited. For current employees, Ms. Gray, there is no impact because right now Current employees who work in organizations that under the federal government purview don't have any time limitations, so they don't have any worries. The huge step forward with this bill is that if you are a former employee, you currently have 3 months, but we are saying that that isn't enough. And that's where C-378 will open the doors, give a breath of fresh air to former employees so that they can file a complaint. But right now, there is no change for current employees.
And we know that there is a lot of conservative leadership for workers. A couple of pieces of bills from legislation from colleagues. We have C-228, which is an act to amend the Bankruptcy and Insolvency Act for companies with creditors, Arrangement Act and pensions benefit standards, and that was through our colleague MP Gladue. We have C-241, an act to amend the Income Tax Act for deductions of travel expenses for trade persons through our colleague MP Lewis. We have an C-409, an act to amend the Canadian Labour Code for hours of work for flight attendants, and that's for through our colleague MP Rude. And then we have C-318, an act to amend the Employment Insurance Act and the Canadian Labour Code for adopted and intended parents. That was through our colleague here in the room from MP Falk. And so your legislation is also another piece of legislation to help workers and to make a difference to them. And so I'm wondering if you can speak for your legislation, what impact harassment and violence in the workplace can have on individuals.
Ils sont nombreux, sincèrement.
Well, there will be a lot of impacts. Victims experience physical, psychological effects. They may have trouble adapting to a new environment. They may experience depression. They may also resort to drinking or drug abuse. They could also suffer on the professional front. They could lose their job. And some groups told us that job loss is very important, because that's where this bill really comes into play. When you lose your job, it's perhaps because you had to leave that job because the situation become untenable. So when you leave your job for psychological reasons, then you fall into the second category, which is, I'm sorry? Thank you.
6 minutes. 6 months.
Thank you, Mr. Chair. Good afternoon to my colleagues. And MP Vian, thank you very much for doing this and your initiative. I can certainly speak to my private member's bill on record suspensions 161 and MP Falk's, again, I believe it was 318. We're all very proud of our private members' bills and, obviously go forth with a lot of passion. Can you just share with the committee the process that you've gone through so far, the consultation? I recognize that you were a previous minister with the Quebec government. What years, MPV, were you minister?
À quel moment j'ai été...
You're asking me when I was minister? You're asking me when I was a minister? From 2016 to 2018. I had 4 portfolios. The last one was the Labor Department. I was there for a little over 2 years, 2016 to 2018. And I even knew your colleague, Mr. Couteau, at the time when I was in that position. To answer your question, or part of it, obviously Quebec's experience is so rich that we can really learn a lot from it. We talked to a lot of groups, unions. Not all of them wanted to appear, but a lot of them nonetheless appeared publicly. And they wanted to express their views on this bill. It's a very good bill for workers. We had discussions with the unions. We also discussed the matter with experts in human resources and victim aid groups who gave us their perspective. Mrs. Viau from the group responsible for helping victims in Quebec. In fact, she may want to appear before you. She has a great deal of specialized experience with employees who have had problems with this deadline. Thank you very much.
Timeline, or I take a 3-month time limit seems too short for such difficult experiences. Employees who are harassed may not always realize it right away. The road is a long one between experiencing harassment, realizing what happened, living through the accompanying trauma, and deciding to file a complaint. The trauma can surface long after the incident and even long after the termination of employment. So, MPVN, my question to you is, you're proposing to go from 3 months to 2 years. Am I correct? So why not 1 year? Why not 3 years? How did you come to decide on 2 years?
Pas de cachette, c'est très...
I'm not going to hide anything here. I took my own experience as minister in Quebec. You have to be reasonable. It's good for the employees, but you also have to think about the employers. Making this change could also have an effect on the business. Even though they're supposed to implement what was in C65, whereby you have to create a zero-tolerance workplace. Why 2 years? Because Quebec's experience is solid, it's conclusive. Everyone seemed to really want to go forward with this 2-year limit, and what I have heard so far is that this is a reasonable limit, and within 2 years, there are very few people who are deprived of their rights because they have gone beyond that deadline. But that's not the case right now. We're being told that, okay, 3 months is there, yes, that's fine. But there comes a time when you may recognize that you have been victim of something, and when you realize it, you realize that the deadline has already passed. And it's so true what I'm saying, that Parliament has already foreseen a process, a mechanism to allow an extension of the deadline. So already it was recognized that the 3 months was probably insufficient.
Thank you, Mr. Long. Madame Sinclair Desgagnés, pour 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Thank you very much for pronouncing my family name correctly. It happens quite rarely. Ms. Vien, thank you very much for your bill. It's hardly surprising that the position of the Bloc is to support this bill in order to align the existing legislation in Quebec with the federal legislation and the Canada Labour Code. Obviously, we're concerned by the fact that 3 months is insufficient for an employee or former employee, especially those of federal jurisdiction, to file a complaint. For me, the 3 months isn't long enough. It could be, if it's a case of serious harassment, it could take years. My first question is the following. You broached us But I was wondering if you have any statistics or witness testimony that show that when you were Labour Minister in Quebec, you amended the labour legislation to make the deadline 2 years. But I was wondering, after these few years, whether you have any information on the effects that this has had on the statistics in Quebec or on the Quebec experience. Thanks for your question. What is unfortunate, and I'll get back to your question a little bit later, what's unfortunate is that I have a lot of trouble collecting information because right now employers are not obliged to collect information on former employees who enjoy this 3-month deadline. In the standing order, in the regulations, what is expected of the employer, it's not indicated that they have to collect information on that. So I have a lot of trouble questioning, for example, how many people right now were about to jump off the bridge because they hadn't met that 3-month deadline. Nobody holds any keeps any statistics on that. There is no statistic that is given to you because the businesses don't have the responsibility to do so. So if we want to do something with this bill, we could recommend that the government force businesses to keep documenting all of the events. There's Cindy Bio, for example, who is responsible for an organization in Quebec who says that at the provincial level, we've recognized that very few people who contact us have difficulty taking steps to file a complaint within 2 years. Since the amendment to the bill in 2018, there have been very rare occasions that we had to tell a victim that the deadline had passed. I can't have better proof than from a group that works with victims. They tick a lot of boxes because they say it's reasonable. They say it's enough for the employees to file a complaint. With regard to the current 3 months, Ms. Vio is a little bit stricter on that front. She says that, yes, there are a lot of employees who have trouble meeting that deadline. Very often, it's because of the trauma that they have experienced. Thank you for those explanations. With what you've just said on the Quebec experience, wouldn't you have liked your bill to include the obligation to collect information on the employees? Well, yes. When we looked at the reports, those data were not available. Perhaps they are somewhere else, but we didn't actually go and delve into that area. Indeed, if there were a possibility for Quebec to go to court to get some documents on the situation of former employees, that would be good, especially since we're dealing with this process right now. I think it would be a good idea. So why not do it right now? Because the bill is being it's at the study stage right now. Well, that's something I realized too late in the process. When I worked on this bill, I noticed that the 3 months indeed wasn't very well documented. In fact, what I mean by that is that the number of cases where the 3 months was insufficient was not sufficiently documented. You partially answered the question that my colleague asked earlier. For example, in France, since 2017, the amount of time given is 6 years. You have 2 years in Quebec, and now you're asking for 2 years at the federal level. Why not try to get more? Because, as you said, sometimes it can take years for someone to get over case of serious harassment. So why not go even further? Why not be more reasonable and more empathetic towards the employees or former employees? Well, you're saying only 2 years. Well, that's certainly more than what is granted elsewhere in Canada. So we are fortunate in Quebec. The Quebec example is very conclusive. I think that we have to have a moderate approach. I think we have to get all of society on board with regard to the deadlines that we want to impose. I looked what was going on elsewhere. I think most of the countries of the G7, actually. Thank you. Ms. Cirillo, for 6 minutes.
Thank you so much, Chair, and thank you so much for MP Vien for this amendment. So this amendment to the Canadian Labour Code is a necessary and overdue measure to protect workers from the lasting impacts of harassment and violence. These are the measures that New Democrats, the only Labour Party in the country, have been fighting for decades, and it would certainly hold employers accountable, empower former employees, and align with the NDP's fundamental principles of justice and fairness. So I want to thank you, MP Vien. And we must also recognize the broader context in which this bill would operate in light of the ongoing federal Black class action lawsuit with the federal government, which is a landmark legal action addressing systemic discrimination and harassment faced by Black employees within the federal public service. For decades, these workers have reported experienced pervasive racism, barriers to advancement, and a hostile work environment that undermine their dignity and professional growth. Lack of protections in the Labour Code has meant that Black employees had to create their own class action lawsuit to seek the kind of justice and comprehensive redress New Democrats know workers need and deserve. This highlights the urgent need for legal protections and accountability measures by extending the time frame to file complaints and hold employers accountable. New Democrats believe this bill will provide an indirect support to those aims of the class action lawsuit, which would ensure that those who have suffered longstanding discrimination would have the opportunity to seek redress and contribute to the creation of a fair and more inclusive workplace for all, which I'm sure all of us in committee want. I'm worried, MP Vien, that the current delays in the Conservatives current delays that the Conservatives are perpetuating in the House of Commons is slowing down this legislation and other legislation. What is the timeline that this change to the Labour Code could become a reality? And what do you feel is the impact of the House of Commons delays on workers?
Vous me posez un piège dans lequel j'embarquerai pas.
Well, that's a trick question that I'm not going to answer. Obviously, this bill is excessively important, and it's something that I feel extremely strongly about. Right now, the employees under federal charter have a 3-month timeline. They have 3 months to express their views. That's insufficient. So the sooner the better to pass this bill. There are procedures in the House whereby there could be delays, but it would be really good if we could move forward. It would be a huge step forward for federal employees.
I agree, and I think that there's many private members' bills that are very important that MPs have passion behind, that they want to get moved forward. So I hope that we can see this move forward. I hope the Conservatives make some decisions to get more work done. In the meantime, we do need mental health supports. We need mental health supports. It's necessary for all workers, not just federal workers. I'm wondering, MP Vien, did you hear in consultation on the need for accessible, affordable mental health supports in Canada? And does the government in general need to expand mental health supports for Canadians? I know they've committed. We haven't seen the money flowing in any in any speed.
Merci.
Thank you, member, for your question. No, to be very honest with you. There was a question of these additional services and additional funds that were supposed to be available through this bill. The bill dealt mainly with the feasibility of this bill and the advances that this could have. Obviously, if we pass this bill, it will have a positive and widespread effect on the mental health of employees. That's undeniable. But we didn't venture into that territory. People who did raise that question did not elaborate.
During the initial tabling of this bill, there was a number of gaps identified by New Democrats, and one of them was accountability and kind of that check back to see if this is working, if this is improving the lives and the work experience of workers. Do you have any comments about the acceptance of an amendment around expanding some and having some accountability in the bill?
Merci pour la question.
Thank you for your question. Yes, we discussed this with the member of Terrebonne in our exchanges to determine whether I'm sorry, I'm not a legal expert here. I think it would be a change to the regulations so that it would be someone else's responsibility to look into this. Well, certainly you are going to look into this, but I was wondering whether we could increase the accountability of businesses to the government and to document all of the files pertaining to former employees. I think that would be a good idea. It would be an opportunity to see what is really going on in the real workplace if we knew how many people had benefited from this extension, because that extension is going to be there. And right now there's an extension for the 3 months, but now it's going to be for an extension on this 2 years. So it would be very beneficial to have more data, and therefore we have to impose more accountability.
You've gone over quite a bit. Ms. Falk, 5 minutes, please.
Thank you very much, Chair, and thank you, Ms. Bien, for being here today. I just do want to make a note off the top. I found that last question about accountability from the NDP quite comical. There's been several times in this committee where we have, as Conservatives, moved amendments to government legislation. One that comes to mind is the $10 a day daycare, which they voted against. So I would take that for what it is from the NDP. All employees deserve respect and assurance of safety within their workplaces. And I want to thank you for taking the time and doing the work for advancing this important piece of legislation, which empowers workers and advocates on behalf of those who have experienced workplace harassment or violence. So as has been discussed, C378 proposes to extend the current 3-month deadline for former employees to file a harassment complaint to a full 2 years. Under the current framework, while the extension is possible, the burden of proof rests on the victim to demonstrate why they were unable to meet the original deadline, requiring them to prove that their circumstances made it difficult or impossible to file a complaint within that initial time frame. I was just wondering if you could please comment on why it is inappropriate to put that burden on a victim or on the victim from that workplace.
The victims are already experiencing trauma when they file a complaint or when they indicate that there was an incident to their employee. to their employer, rather. They're already in a state of trauma. And when they're dealing with a 3-month, can you not hear the interpretation? Hello? Well, there's the burden of proof that comes into play. When a former employee wants to have an additional extension that goes beyond this 3 months, if the person wasn't able to meet that deadline, it's really up to the complainant. They have to first claim that they experienced trauma or that you had a health problem to justify that you were not able to file a complaint within the deadline. It doesn't stop there. You have to produce documents. Perhaps you have to go to a notary and have some things notarized. You may have to produce some medical records. There are all sorts of documents, all sorts of requests that are being made. You have to have sworn documents. I have 2 pages here, 2 full pages of things that have to be produced. So it's enough to discourage anyone. Let's say you're experiencing post-traumatic stress, or you're depressed, or you're wading into territory that is totally unfamiliar. It gets really difficult. And so all of this falls on the backs of the victims. I'm convinced that there isn't one parliamentarian who wanted that to happen, but that is exactly what's happening today. So at least if we could extend the deadline, that additional burden would perhaps be reduced. It would certainly facilitate the procedure for those former employees. I don't know if I answered your question. Yes?
I think that's something too that society is continuing to unpack, that processing trauma isn't black and white. It's very gray. And there you can't really put a timeline on processing that. So would you say, from your perspective, this 3-month deadline that's current, would you say that that is actually a discouragement to those that would be coming forward with a complaint, in the sense that that's just not enough time? Would you say that that would be like, just I haven't even thought through this, or it's not a big deal, but as they're processing it afterwards, do you think maybe complainants would look at that 3-month and say, oh, no?
Well, I wouldn't be the least bit surprised. It's a major block, that 3 months. They may not even know about this deadline. The victims may find out about it later. I'm talking about witnesses, people in my entourage who experienced that. When they wanted to file a complaint, they learned that there was a deadline to do so. And they said, darn, I missed the deadline. And I'm talking about a number of people here.
Okay, Mr. Fragascatos for 5 minutes.
Merci, Monsieur le Président. Madame Vienne, merci.
Thank you for your work. I think the legislation in Quebec came into effect in 2018. What has been the Quebec's experience with this bill? You said there were positive results. It's been in effect maybe 6 years now. So you have 6 years of experience. So obviously you can express your opinion on it. Well, unfortunately, we didn't get a lot of data, except those from the from Santé Sécurité des Normes au Travail, an organization that deals with labor standards. Now, I'm not going to surprise anyone by saying that there's an increasing number of incidents of violence in the workplace, and we know what kind of trauma can be experienced in the workplace. But we don't have much information on the effect of this additional time, i.e. the 2-year deadline. There are some groups, like the one I referred to, Ms. Vio's, who have said that the experience has been conclusive. There are very few people who have gone to her organization and realized that they didn't have enough time to file a complaint. She gets very few of those cases now. So it shows that this 2-year limit is working, but when it comes to the 3 months, there were people who didn't realize that the deadline had already passed. So there are recommendations that everyone should have what Quebec has, i.e. the 2 years. Now, you said that you've consulted other G7 countries. I would like you to tell me a little bit more about that because it interests me. We looked at what the experiences of other jurisdictions were, and it was very interesting, but it was also very complicated. So there was an attempt to link the procedures being carried out in the workplace and criminal proceedings. So it's not quite the same situation as here. I'm usually very prudent, and I would recommend that the House move step by step. We didn't have anything. Then we got 3 months. We collected some statistics and looked at what Quebec did with this 2-year period, and it looks good. And if later on we realize that 2 years isn't enough, then maybe we can look at what's going on elsewhere, like in France or in Belgium. But I think that we need a gradual, prudent approach because there's also the impact on businesses. I think that 2 years is a lot compared to what currently exists, but that doesn't stop us from making further changes down the road, perhaps extending that deadline. I don't think it's going to be reduced in any case. With regard to the consultations, I'm sure that you have organized quite widespread consultation on this question. How many organizations did you consult? Was there common ground with regard to this 2 years? Well, I can say that the National Assembly unanimously accepted these changes. Everybody was in agreement with what was going on at the National Assembly. We consulted a number of groups. We invited a number of groups, and a number of them did not want to express themselves publicly on the matter. There are always reasons that are valid for them, but I didn't meet anyone who said outright, this is a bad idea. Nobody. No, that's no surprise. Thank you.
Fregus Caros. Madame Sinclair Desgagnés pour 2 minutes.
Ms. Sinclair Desgagnés. Thank you, Mr. Chairman. At one point, you said that you recognized during your work, i.e. when you were preparing to table this bill, that there was no obligation for businesses to collate information on former employees. Did you make any other observations during your work, similar to what I just said, to perhaps improve the Canada Labour Code? I would say that that was the major thing that struck me, that we had to collate some information. As I said to your colleague, Ms. Falk, I'm sorry, I've lost my train of thought here. Sorry.
Madame, à vous la parole.
You have the floor. Perhaps you could repeat the end of your question? Sure. It's on the observations that you made when you were preparing for the study. Obviously, you had some consultations, and you noticed that there was no requirement for employers to collect information. In my answer to Ms. Falk earlier, I said that perhaps it would be advisable to look at the regulations pertaining to the tasks that are required of the victims who are perhaps experiencing some trauma. Perhaps you could lighten the load. They may have a mental health problem or some other problem. You know, when you have to go to a notary to have some documents notarized. Well, that's a burden. Perhaps we could just have the person swear that they're going to tell the truth, the whole truth, and nothing but the truth. If the burden is really onerous, I think something could be done. There should be a review to make the workload lighter. We understand that there has to be some proof, yes. Obviously, there have to be some checks carried out, but I agree with you that it is too onerous right now. Thank you. Ms. Sinclair de Gagné.
Thank you, Chair.
2.5 minutes.
My NDP colleague, Matthew Green, outlined in the initial debate of this bill that coordination with stakeholders, including provincial bodies, is important. Since the labor laws vary significantly, which you outlined initially in your presentation around the timelines, how can this bill be amended to assist in coordinating with the provincial labor laws to ensure consistent protection for all federal workers right across Canada?
But
Well, I would say that if we pass this bill, we're going to send a message. We're going to send a message across Canada to all provinces, because a lot of the provinces are already in a good position. They do a lot better than what the Canada Labour Code does. With what I said earlier, that if we can improve the obligation to collect more data, to have more transparency and accountability, but the legislators will also be able to see what's working and what isn't and what has to be changed. I think that passing the bill would be a thrust for the other provinces to do something. It would be really good to do something for former employees.
I just want to go back to the idea of data. It's been mentioned twice in our interactions today. So on the data side, and how can privacy be protected? How can you see that data being stored or analyzed or shared, but still protect the privacy of employees?
je ne suis pas dans les opérations.
I'm not really going to look at how the businesses are going to collect the information, but it seems to me that the data are already protected. I have some data here that come from different organizations the CSST or from the annual report that the government produces every year. So the data provide an idea of the numbers. Unless I misunderstood your question, I don't know how we could jeopardize the confidentiality of the information.
What I'm thinking about is
Merci.
the personal information of employees. Sorry.
Merci,
Sorry, Chair.
Madame Zerillo. Mr. Aitchison for 4 minutes, and then we'll conclude with Mr. Coteau. Right? Mr. Aitchison.
Thanks, Mr. Chair. Merci, Madame Vienne.
Thank you, Ms. Vienne. It's a very good bill and very reasonable. A private member's bill.
The questions that I had have been asked. Is there a specific point that hasn't been made that you'd like to make at this point?
Ben, je pense qu'on a fait.
Well, I think we have really covered all of the possibilities that this bill could bring. Harassment is insidious, whether it's sexual or psychological. You know, the borderlines are very gray. It's a gray zone. And when I talk about violence, yes, there is some information available, and really it defies all logic. I am very pleased. Well, I would like there to not be any deadline for all of federal employees, all those who fall under the federal charter. In Quebec, there's a 2-year deadline. But for former employees, here in Canada, it's worse than in Quebec. Everybody could just say, well, I mean, it doesn't take tons of studies to understand that 3 months isn't a very long time. I could come up with all sorts of academic studies, and everybody knows that 3 months is not enough. So why don't we all work together? I think all parties agree on this. There isn't an issue here. And that's why I don't want to start talking about 7 years and 10 years, at least not for now. Businesses also need time to adapt to this, to understand what's going on. So I think that this would allow everyone to move forward at a reasonable pace, and later on we can look at whether we got the results that we expected, whether there are any changes that should be made or not. But I think it would be reasonable.
The operative word here is reasonable. I think you've made that point very well. Monsieur le Président, je peux donner mon temps de Madame Gray.
Mr. Chair, I would like to give my time to Ms. Gray.
Much, and I want to thank Ms. Vienne again for a very good and well thought out bill. Thank you very much. We're in the last couple of minutes of this meeting here, and so I'd like to bring another issue forward that's very, very important. And this is in relation to the 2024 report card on child and family poverty in Canada. Which stated that nearly 1.4 million children live in poverty in Canada, or roughly 1 in 5 children. And this is the largest annual increase in child poverty on record, and this is an increase 2 years in a row. Canada saw 358,520 more children living in poverty than during the height of the pandemic, even in 2020. And we know that this is across every province and territory. Meanwhile, as well, the cost of food also has increased 35% since 2015, and the percentage of children living in food insecure households also rose in 2023 to now 28.5%. Very shocking numbers. And so therefore, Mr. Chair, I would like to move the following very short motion, which has been put on notice. I move that given that recently published numbers from Campaign 2000 indicate that between 2021 and 2022, Canada experienced the largest jump in child poverty on record, the committee report this concern to the House. And I'm sure that all members of the House all members of this committee can approve of this. Thank you, Mr. Chair.
The motion is in order, and Ms. Gray was in position to move it. Discussion, I have Madame Zarillo and then Mr. Fragascatos. Madame Zarillo, on the motion of Ms. Gray's.
Thank you, Chair, and I really appreciate this motion from the Conservative side. So, Campaign 2000 and other civil society advocates have been at the forefront of activism to end poverty for families in Canada. This is clear with this latest report card, and previously we have seen this work in their successful efforts to protect the Canada Child Benefit from clawbacks. At the time, Campaign 2000 urged the government to take the lead in entering into agreements with provinces and territories to ensure that families wouldn't see this needed income clawed back. We're seeing the same problem emerge now, though, with the Canada Disability Benefit. In the data this motion refers to, it shows how children with disabilities and their families are disproportionately experiencing higher poverty rates. We must ensure that just like the Canada Child Benefit, the Canada Disability Benefit doesn't face clawbacks, or we will only see child poverty get worse for the most vulnerable. So I have an amendment, Mr. Chair. Given that recently published numbers from Campaign 2000 indicate that between 2021-2022, Canada experienced the largest jump in child poverty on record, and children with disabilities, particularly young women and girls with disabilities, are disproportionately experiencing higher rates of poverty. Clawbacks to benefits perpetuate the cycle of poverty for people living with disabilities. The Canada Disability Benefit has not yet been safeguarded from clawbacks and would provide needed relief for people with disabilities and their families experiencing poverty. In the opinion of the committee, it is imperative that the government take the lead in engaging with provinces and territories to ensure that the Canada Disability Benefit does not face clawbacks by ensuring similar exemptions as were secured for the Canada Child Benefit by Campaign 2000, and the committee report this and its concern over rising child poverty to the House. Thank you, Chair.
Zarillo, we now have an amendment on the floor to the motion of Ms. Gray. Mr. Fragascatos, you had your hand.
Well, I haven't seen the amendment in text form, Mr. Chair. I do see it's 1 o'clock, and so I would be happy to take up the matter another time or the next meeting or whenever colleagues wish to raise it again.
Okay, we're now moving. Is it the wish? Madame
Point of order, Mr. Chair.
Yes.
Just want to be ensure the amendments have been sent to the clerk in both official languages, and I'd like them to go out immediately, please.
You're correct, Madame Zarillo. They will be circulated, but at this time you've moved an amendment, and I am now beyond the hour. So, is it the wish of the committee to adjourn?
No. 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 No, Mr. Chair.
Then we'll vote. Is it? I'll ask the clerk to call a vote on the adjournment of the meeting. The adjournment of the meeting.
Mr. Fragascatos?
Yes.
Mr. Long?
Yes.
Mr. Collins? Yes. Mr. Coteau? Yes. Ms. Yip? Yes. Mrs. Gray? No. Mrs. Falk?
No.
Mr. Moore?
No.
Mr. HSM?
No.
Madame Sinclair-Desgagnés? Oui. Ms. Zarillo?
No.
Yeas pour 6-6, nays contre 5-5.
Is adjourned. Meeting adjourned.